Welcome everyone to the FASEB webinar, Know Before You Go, Tips for Foreign Scientists Traveling to U.S. Meetings. We still have a few people logging in, so we are going to start in about a minute, but just wanted to let folks know to please stay on the line and we will get started shortly. All right, welcome everyone to the FASEB webinar, Know Before You Go, Tips for Foreign Scientists Traveling to U.S. Meetings. My name is Jennifer Zeitzer, and I'm with the Office of Public Affairs here at FASEB, and I'm joined by our speaker, Brendan Delaney, who I will introduce momentarily. Thanks everyone for joining us for this webinar. Wanted to make a couple of announcements before we get started. First, we are recording this webinar, and we'll have an archive version available on the FASEB website by the end of next week. Everyone on the webinar will also get a post-webinar email from us with a link to the recording if you want to rewatch it or share it with someone who couldn't be with us today. Second of all, we will have plenty of time for questions and answers after Mr. Delaney's presentation today. The only thing that we ask is that you submit your question in writing because we have muted all of the phone lines to minimize any interference. So there is a question feature with this webinar, and we'll talk about that in a minute. Can we advance the slides, please? So to ask a question, you can look at your screen here and use the orange button to type your question in the white box and click send on the gray button down there. Don't worry, we will not grade you on spelling or punctuation or grammar. We simply ask you to submit the question in writing so that everybody has an opportunity to ask a question. Again, we should have plenty of time for questions during this webinar. So you are welcome to submit your question anytime you think of it, or you can wait until the end, whichever works best for you. So I'm pleased today that we are joined by Brendan Delaney, who is an attorney with the firm of Frank & Delaney Immigration Law, LLC, which just happens to be located here in Bethesda, Maryland, down the street from FASEB. Mr. Delaney is actually a native of Northern Ireland, but received his JD from the Catholic University here in Washington, D.C. His work as an attorney has focused on representation of foreign-born nationals and U.S. employers with regard to immigration matters. He has a lot of expertise on various types of visas, including the EB and 1B visas, the J visas, H-1Bs, and O&P visa applications, which is part of the reason why we asked him to join us today. He has actually worked both in helping to secure visas through the E&L process to assist investors and other companies who wouldn't wish to do business in the United States, as well as assisting them in transferring employees from foreign and corporate offices to the U.S. He has worked extensively with the scientific and research community, physicians and other professionals in both academia and industry, working on issues related to both temporary and permanent visa applications. So he is the right person to join us today for this particular webinar. We also wanted to note that Brendan has been working with the National Postdoc Association on visa issues there, which is how we came to engage him today. So I'm going to go ahead and turn this over to Brendan, and then again, we will have plenty of time for questions and answers at the end of the webinar. Brendan?
Okay, thank you so much. So first of all, thanks to FASEB for having me here today. And just before we start, this is an informational session, informational and educational purposes. So this is not necessarily or shouldn't constitute legal advice per se. I just want to let you know that any questions you guys get or any specific questions that people may have with regards to a personal or particular situation, you should talk to an attorney or someone with regards to your personal case. So just, I think, keep in mind that these are sort of general issues and general concerns that we're going to touch on and discuss today. So with that in mind, we will go ahead and get started. And some of the sort of catchwords today are going to be that. You're going to hear that again and again today as we navigate this, because what we're going to be talking about in the audience that we're going to be speaking to are foreign nationals outside the United States, because People who are here inside the United States to attend these meetings will, or of course should have, some type of status to be here. So they'll be fine. So these are the folks that are outside the United States and need to be prepared to travel to the United States and navigate the visa process to get here to attend your meeting. So one thing to do is obtain a letter of invitation. Obtaining a letter of invitation from the Scientific Society is important because that can show the consulate the individual is coming for a bona fide purpose. And some of these issues that I just want to sort of note at the outset are sort of, housekeeping. It's, remember to check your passport. The passport might have been sitting in the drawer for a while. Generally speaking, you're going to have 6 months of validity from the date of your return to the U.S. So it's going to have to be valid for at least 6 months. And ultimately, I think it's important, and hopefully as people walk away from this today, they will be more familiar with the process and the necessary information that we're going to guide you through, because it is important to be familiar with what's in front of you. And also know which process applies to you. Certain people, certain individuals, it may be in fact applicable that 1 or 2 different options may apply to them. So it is important to know which is the most appropriate process to follow. So I'm going to start with the visa waiver. The visa waiver is in effect a process by which multiple countries can come to the United States without having to actually apply for a visa. There's a list of countries there on that link. The travel under the visa waiver must be for a purpose that is also allowable on a B visa, either a B1, which is business, or a B2, which is travel and tourism. So therefore, participation in a scientific conference is an appropriate use of the visa waiver process. So if you're from one of those countries, the easiest and the path of least resistance, I suppose, is to attend your conference using the visa waiver system. You have to register in the ESTA system, so you have to give your details to the US government to make sure that this is an appropriate process for you to pursue. Now, there's a couple of points that are important to note about the visa waiver process. Who's not eligible? So let's say, for example, as was pointed out at the outset, I'm actually from Northern Ireland, part of the United Kingdom. So if I wanted to come to the United States to attend a conference, I could do so using the visa waiver. However, if, for example, I or a national of a visa waiver country had actually traveled to or been present in one of the following countries, Iran, Iraq, Libya, Somalia, Sudan, Syria, or Yemen, on or after March of 2011, they are actually ineligible for the visa waiver program. Also, if you are a national of one of those, of certain countries, Iran, Iraq, Sudan, or Syria, you are also ineligible to use the visa waiver program, even if you hold a passport of one of the countries noted in the link above. Thirdly, if you have previously violated the terms of the visa waiver program, you must apply for a B1. Now, one of the common issues that we see here is that if, for example, someone came here in their youth on the visa waiver program, were traveling around the United States and actually overstayed, and instead of going home within 88 or 89 days, they stayed for in excess of 90 days, even if they are from a country that can use the visa waiver, they would actually have to go and get a B visa because they would have previously violated the terms of that. So how do you apply? Again, if this applies to you, this is the path of least resistance. This is the process to take. Go to the government website and complete the application. You can go and check your status at that same website. And once you're approved, you can travel to the United States using the visa waiver program. So you shouldn't have to go near the consulate for this. However, there are obviously many people that this doesn't apply to. And so therefore, if you're not eligible to use the visa waiver program, in order to come to the conference, you're going to have to obtain a non-immigrant visa, i.e. a B1 or B2. Now, the first thing to note is that around the world, review your own consulate website, because the many different consulates have local rules that may be different in their nature. So it's important that there's no sort of one size fits all, I suppose, in that regard. So it's make sure, as I sort of said earlier, to familiarize yourself with your process and to make sure that you are familiar with the rules and regulations of your consulate. In general, you will need to complete a DS-160, which is a temporary and non-immigrant visa application online, and then you submit that with your digital pictures. Once that's done, you make an appointment for the interview. Again, you do that online, and you pay the non-immigrant visa fee to the U.S. government. There's a second appointment, you get your biometrics done so they can go start checking you out. And generally speaking, when you make this application, the B1 is the appropriate visa to request. That's the business visa, and you're coming here for a scientific conference generally. However, you may see, hear, or read about what's called the B1, B2. It's fair to say that these are sometimes, or in many occasions, sort of talked about interchangeably. So even as you apply under the B1, if, for example, the application is made under a B1, B2, that's not really problematic. The consulate officer and the consulate will know what you're pursuing. So in terms of everybody who can't use that visa waiver, this is going to be the general process that they follow. When you go to make this application, I think one of the most important aspects to point out here today is that in addition to having the letter of invitation and other information which shows that you have a bona fide reason to visit the United States, the consulate has to understand that you have legitimate reasons to convince them that you will in fact return to your home country. And that brings us to what's 214B. And 214B is in effect what's called home ties. Do you have enough ties to your home country to convince the U.S. consulate officer that you will in fact return? So ultimately, when you process a B visa application, it's important to have information ready to present to the consulate to rebut what's called a 214B finding. And that would be information such as wages, a letter of employment, or housing and other living details at home. So when you turn up for the interview, what's in front of you, what to expect, how do you deal with it? And just like everything in life, I suppose it's better to be prepared and be organized. And the better prepared and organized you are, I think the better off you are. You're not going to have a lot of time. You're not going to have a lot of time in front of the consulate officers, especially in certain countries. I mean, it's fair to say, without getting into sort of details, numbers, wait times, certain countries have an extraordinarily high amount of visa applications to the United States. So you may be in and out of there quickly, and you maybe have to answer questions and process this application in an extremely quick manner with the consulate. Important to note, just answer each question truthfully. Answer each question fully, but at the same time, I don't think there's any need to volunteer information outside what I would term the parameters of the question. The consulate officer may have a quick question, give them a direct, specific, and on-point answer. If you don't understand the question, it's okay to ask them to repeat or rephrase that. But again, going back to what we sort of mentioned earlier, it's important to be familiar with how and why you are presenting yourself. Have the documentation in front of you ready to present to back up any claim or assertion you are making. You know, again, that letter of invitation, if you're going to a conference, bring your registration information, any hotel reservations, acceptance of abstracts, etc. And again, to go back to that point that I made on the last slide, be ready to show those home ties, because this visa interview is not just about the bona fides of your trip to the United States, which let's be honest, it's clear. You're coming to a prestigious, legitimate scientific conference and event to perhaps speak or attend. So the bona fides of the trip is solid. So be prepared to show those home ties. The job security in your home country, lease or ownership of property, wages, family ties, things like that. And I think it's fair to say that the 214B aspect of home ties is a portion of the visa application process that many people overlook, and it can lead to visas being denied under the 214B process. At the end of the day, the officer on the other side of the window is doing their job. So I would also suggest to be courteous, even if the officer is not. you know, sometimes the old adage, you know, a please and a thank you and a little bit of politeness goes a long way. So remember to be courteous in the interview process. So what other aspects are we looking at? What other issues are in front of us that we need to think about? The big one is administrative processing. Unfortunately, I don't have a specific answer on this because it's a catch-all. Section 221G, it basically allows a consulate to delay an application or to delay giving an answer because they need additional time to deal with the application, to in effect assure that the applicant is qualified and admissible. But as I say, it's a very catch-all process and it can affect many people, and it can be very difficult to know why in fact you are under administrative processing. Technically, as is noted there, it's generally seen as a delay in adjudication, but in some instances, from a practical standpoint, it can be treated as a denial, and it may lead to someone having to reapply many times. Generally speaking, there's going to be two main reasons, and again, as I noted at the outset, this does not necessarily cover everything, but in general, the two main reasons that you would get a 221G administrative processing letter is either that you need additional clearance from the United States, or the consulate needs time to conduct additional research. If it's because of U.S. clearance, it could be because of criminal activity, it could be security issues, or technologies with regard to sensitive technologies and things like that. Or if your name is, for example, similar to someone with criminal activity or is on a no-fly list or terrorist ties, that could certainly trigger additional processing in your case, even though it may not be you, but it could trigger the additional processing and timelines. If the consulate causes delay, the most probably common issues would be they could be researching a legitimacy of a marriage, if this is if you have a marriage or other family members, or previous work background, the existence of the sponsor, which goes back to our letter of invitation, or, for example, authenticity of documents. Now, some of those issues probably pertain more to the application under certain work visas, but those are probably the most common issues that affect people. As we say there, we need to keep on the consulate to get them to finish the research so they can issue the visa. This also, however, goes back to be prepared and starting early, because right there, 221G, administrative processing, is probably the biggest single reason to start this process early. Because if you get caught up in an administrative processing issue, then it can be problematic, because the consulate, at times, it can be hard to sort of push them ahead with what you need them to do. So perhaps the next question is not when you should apply, because we're telling you to apply early, but rather where. Where should one apply? Now, generally speaking, you should apply in your home country. That is, when we go back, if we cast our minds back to the home ties issue, then that generally allows you to show closer home ties than applying elsewhere. If you're residing in a country other than your home country, which would potentially apply to people perhaps in Europe, things like that, but you can apply there. They should allow you to apply there as long as you can show perhaps that you're a permanent resident of this country or you have other strong ties. Deciding where to apply can be important at the outset. There are certain consulates that will process cases for third country nationals. There are certain countries that may not have a U.S. embassy or consulate, and also in if you're residing in the United States, although this may not be applicable to the current audience, usual consulates in Canada or Mexico can process cases for what we call third country nationals. But that's where you should apply. I mean, generally speaking, it's for the most part going to be within your home country. That's where you're going to be living. That's where you're going to be working. That's where you're going to have your ties. So once the application process gets underway, how long is it going to take? Well, how long is a piece of string, as they say? Because each consulate has different timelines. I mean, we have a link there with different timelines that can be available to you so you can take a look at it. You can put in your own consulate and see what the sort of wait times look like. One example there is Abu Dhabi. The wait time most recently that I saw for a visitor visa application is 8 calendar days. Now, it's important to note that that's the time to get an appointment. Okay, so when you look up the wait times based upon that link, this doesn't consider how long it takes to process the application. This doesn't consider how long that it may take if you get involved in administrative processing. This simply means this is their wait time to get an appointment. So if, for example, you are residing in a country and are going to go to a consulate whereby the wait time is lengthier, I think it's also fair to say that then the potential is that the processing time will also be lengthy. So it's important to look at this before you make your own decision in terms of when to get this process started. There's one thing to note, and this is going to be also important as we sort of transition into the next slide, I suppose, is that you have to understand as you walk into this appointment that your entire U.S. immigration and visa history is in play. This is not just an appointment and an interview about the current application. Everything in your past history can also be reviewed. And why is that important? It's important because there are issues out there that can come up that may now be in the system that may not have been previously. Now, there's a couple of main issues, I suppose, that we want to make you aware of, that you need to be cognizant of as you make this application. First of all is the idea of misrepresentation. Generally speaking, when one is requesting or attempting to obtain a U.S. immigration benefit, as noted there, a non-immigrant visa, the misrepresentation must be material to obtaining said benefit. However, I think, and this will also be noted in some of the slides that are to follow, we are in an era of heightened scrutiny and extreme vetting. There are reports, and some of this is hard to quantify, that any misrepresentation can and could be used as an excuse to deny an application. So that goes back to what I mentioned in one of the earlier slides. Be truthful, be honest, and be prepared. If, for example, a misrepresentation issue comes to the fore in your application, you can attempt to ask the U.S. Department of State to intervene, but this is going to take a significant period of time. This could be one of the issues or aspects that we talked about under the administrative processing. It can also be made more difficult in that the consulate may or may not even tell you what the misrepresentation was. So they may have something in their record on you, for example, from a previous U.S. visa application or similar, that they are now in effect holding against you in this visa application. So be truthful, be honest, be upfront, and be clear in any of your answers in the interview. In terms of the criminal issues that are potentially out there, I think that, as I note at the bottom there, if there are any issues like this applying to you, it's important to get individual professional advice before you start navigating this process, because you need to know what's in front of you with regards to that. Now, without getting into specifics, there are obviously a lot of different crimes, misdemeanors, and things like that. Department of State, USCIS, and Customs and Border may not overly agree or be consistent in terms of whether crimes render someone inadmissible for admission to the United States. The next point is actually important, mostly for UK nationals, but I'll use it as an example because I'm not 100% sure if there are similar issues in other countries. A caution in the United Kingdom does not necessarily constitute a conviction or an admission of guilt in your country. However, generally speaking, it can be considered to be seen to be an admission of the elements of the crime that transpired, and therefore, even though it may not be an admission of guilt by you in your country, can be considered to be an admission of guilt by the consulate and can render you inadmissible for a visa. So if you've had any criminal background, if you've had any arrest, citation, or detainment by law authorities in your home country or in the United States previously, I would certainly advise you to contact an attorney to get a full sort of review of your situation before you make an application. So what other sort of issues are we looking at in terms of some crimes and then moving into the idea of social media? Some other possible issues with travel include alcohol-related arrests. This is important. Even if you have already been in the United States or are in the United States, the Department of State may revoke a visa that has already been granted, even if you are not convicted of the offense. So if, for example, you got a DUI or a DWI, and even if you were not convicted, you will have to, in all likelihood, go to a physician before the visa appointment to show that you, as the applicant, are not alcohol dependent. And I can't stress this enough, that this does not even require a conviction. And this goes back to the previous slide where I mentioned that any arrest, detainment, or citation by law enforcement needs to be brought up and reviewed before we sort of navigate this process. And one of the things is this can be inconsistent. Doctors, physicians in different parts of the world are viewing this slightly differently. What about social media? Well, everybody uses it these days, so I think this is in play for most, if not everybody. And I'm going to preface this by saying that some of the information that I'm sort of noting here is difficult for me to provide sort of tangible examples or be able to quantify the extent to which this is happening. Suffice to say that in terms of someone's social media on a phone or computer or tablet, Customs and Border can look at it and they can review it when you are crossing the border into the United States. So it is in play to have your phone or tablet or computer reviewed and searched by CBP. There is currently a State Department initiative to request that any temporary visa applicant to the United States, that they will request usernames and details for your social media accounts used over the last 5 years. To my understanding, it is not currently in process, and that is an initiative that they are hoping to pass. It is possible that this, as they look at posts, as they look at other aspects of your social media, are they looking for anti-U.S. posts on social media? That's not for me to say. I don't know. But again, I think it's fair to say we are in an era of heightened security, extreme vetting, scrutiny, whatever you want to call it. And so therefore, to be aware of this is important as you sort of navigate your travel to the United States. Speaking of travel, the U.S. currently has a travel ban. It is in effect. We were speaking before the webinar started. It's currently caught in the courts, so it's quite difficult, I think, to surmise or provide a sense of where this is going. Suffice to say, right now, there's a number of countries affected by the ban. Review it, know whether you are affected. There are certain ways and means that where you may be a citizen or national of one of these countries, if you have dual citizenship, you may be eligible to get the visa on your other passport. So look at the parameters of this. Certainly dual citizenship is one of those. In addition, we are seeing, or we know that there is the potential to get a waiver to these restrictions. However, without getting into the specifics or the details, I will have to caution everyone that these waivers are very rare. Very difficult to know, very difficult to say how in fact they are being granted and to what extent they are in fact being granted in terms of numbers of them. Here's a couple of other notes. Basically, dual nationals, as I noted in the last slide, you can still travel and get a visa based upon a separate nationality, aside from the list on the previous slide. So for an example, if you're a national of both Iran and Canada, you can still get a non-immigrant visa or immigrant visa based upon Canadian nationality. Secondly, those in the United States at the time the travel ban takes effect, they are not affected as they are already here. If you have a valid visa, so if, for example, you came to the conference last year and the B visa was issued for a 2-year period or something like that, then you don't need to get a new visa because you would have a valid visa to travel again to the United States, and therefore you would be exempt from those restrictions. If you're a permanent resident, a green card holder in the United States, and a national of one of the countries listed, you're also exempt from the travel ban. There can be other potential exemptions. Again, I would urge people to talk to an attorney or a professional that if you feel you may be affected by the travel ban, and then possible waivers and exceptions to that can be discussed on a personal basis. Finally, you're here. You get here. What can you and what should you do once you come to the United States? It's very important that, whether you're coming here for purposes of today's discussion, the scientific conference to present, things like that, adhere to the requirements of your visa. So if it's the visa waiver and or the B1, B2, for example, go to the conference, attend the conference, present your abstract, etc. You can travel around a little bit, but don't engage in some type of unauthorized employment. If, for example, you come to the conference and a lab mate or a department at a university close to the conference asks you to come and do a little bit of research while you're there, please be careful. The last thing you want to do is engage in what could be considered to be unauthorized employment while you're in the United States in a visitor or other status. And then what's the 90-day rule? Well, what we're looking at is the idea of coming into the United States on a temporary visa, a visitor visa, a non-immigrant visa, and then filing some other application to change status. Generally speaking, the old rule, there would be a presumption of fraud or misrepresentation if an application, a subsequent application, was filed within 30 days of entry to the United States. So, for example, if you came to the US on a B visa and then you filed to change to a student, within the 30 to 60-day period, it would either be a presumption of fraud or misrepresentation, or, as you see there, within the 30 to 60-day period, a rebuttable presumption. Recently, that has been extended, that they are now looking at, the government is now looking at any actions where one could be considered to have violated status within 90 days of entering on a non-immigrant visa. And some examples of that could be if you're, again, coming for a visit for a conference and then you move to change status to H1B as an employment visa. If you change status to F1 to a student visa, then there is the presumption that you misrepresented upon entry to the United States. And I think it's fair to say that however that was to play out, that could have implications for future US visa applications. So, when you're here, abide by the terms of your visa and, enjoy your stay, I suppose would be the thing to say. And with that, I'm going to finish up. I hope that has sort of informed us as to the process. And if anybody's any questions, let me know.
Thank you very much, Brendan. I think that was quite helpful. One of the things and one of the reasons we wanted to have this webinar now is because immigration issues have been in the news a lot lately. And FASEB and FASEB member societies host a number of meetings each year, some of which attract folks from abroad. So there have been some issues and questions that have come up, I would say, within the last year about what the societies can do to help the people who might be applying for a visa in their home country to have them successfully be able to make that application and come to the meeting here in the U.S. without too much of a hassle. So we're going to go ahead now and open up the lines for questions and other things. So one of the first questions that came in, I would be interested to hear others' policy on meeting cancellations due to non-approved visa applications. There's a difference between being denied and not submitting in time for proper processing, and I'm not sure if this is something the speaker can address or maybe as a follow-up to the attendees. So, Brendan, have you dealt with any of these things with your clients?
Well, I think that goes back to the sort of, I suppose, the broader issue of being prepared and having this understanding that we we unfortunately don't have a one-size-fits-all answer to this. If you are from a country that you know or have reason to know that your visa process is going to take longer, then yeah, you're going to have to start quicker. And I think it's also, or start sooner rather, I suppose the correct answer would be. And I think it's fair to say that in the current climate and in terms of current processings, people are going to have to be more prepared earlier. In terms of visa denials, there's a doctrine called consular non-reviewability. So a consulate officer has a lot of discretion in how they adjudicate and review individual visa applications. So that's a little difficult to get into because obviously different individual visa applications are by nature, individual. But yeah, in terms of the timeline and the proper processing, I mean, I suppose I would be inclined to start telling people to look at these things under the 4 to 6 month range. Better to have that visa stamped and processed and done rather than run into these issues closer to the time.
And that's certainly something, as we can talk to and work with some of the FASEB societies to see if they have established specific cancellation policies or updated their policies more recently because of this issue of the time it is taking and the uncertain process that's happening these days.
And actually, just maybe as one other point to that, and actually as a good segue into what you mentioned, is that people should not be making travel plans until they get that visa. So that because whatever sort of policies are there for the societies, the airlines have their own policies. So they want to make sure they don't lose airline fees as well.
Another question that's came back to something you mentioned kind of at the very beginning, Brennan, which is this invitation letter, recommending that people get an invitation letter if they want to attend. How far in advance should a visa applicant request or try and get that invitation letter from an inviting society?
Yeah, and again, this is a little difficult to sort of quantify, I suppose. I think I would be suggesting in the 4 to 6 month range. I think that should give both societies and the individuals a solid time frame to sort of gather the information from the society and then also put together their own information to get the visa appointment in a timely manner. So I would suggest, in the 4 to 6 month range, and so therefore for fall meetings, you would be looking maybe in the spring into the early summer.
So from a society perspective, making sure that the society has a process in place to get those invitation letters out 4 to 6 months in advance probably sounds like something that would be a good practice.
I think that would be good. I think that would be solid for the most part. I think that if an individual or an applicant wanted to, come sooner than that, to have something in place there, but I think that would be a solid timeline for most people.
Kind of in the similar vein, we, the meeting management staff at my society, were asked by a few attendees, mostly from Asian countries, to provide additional materials to help them prove that the intention of their trip is just for attending the meeting only. We were told it's required by the visa officer. How can we provide such information? We have provided a letter of invitation. However, we have no control of the purpose of their trips besides attending airports. Any tips or advice?
Right, and that's a good question. And I'm just going to run back through some of the slides so I think in one of the slides, yeah. So let's say, for example, I think some of this goes back again to the individual basis. So it may depend on how long an individual is coming for. So let's say, for example, the individual has their, itinerary for a 1 week period, and within that 1 week period, sort of the first day or two is going to be taken up with, registration and the start of the meeting, and then maybe they're presenting, and at the end of it, they've got reason to believe that they're leaving and there's a hotel reservation and things like that. I get the difficulty because at the end of the day, I suppose the society or the inviting organization can really only provide what they can provide, and we're not here to necessarily supervise what the individual is doing outside of the context of the meeting, because at the end of the day, issuance of a B visa or entry to the United States on the visa waiver does allow for other activities. So a little difficult to be able to answer but if you give a letter and other information about what the individual will be doing I suppose, under your umbrella during that time period. I don't really know what else you could do beyond that.
I'm going to go a little out of order on the questions here since we're on this topic of invitation letters and documentation, because this is an interesting question. What about scientific societies that will not provide an invitation letter until about a month or so before the conference, once an abstract or talk has been accepted? Is there any way to get around this? Well,
again, I think this goes back to the two aspects or the two parts of this that we talked about or mentioned earlier. You're coming to the United States for a bona fide reason is there, and the letter of invitation is one part of that. However, I think it's fair to say that whether that letter of invitation is issued or not, there will be information out there online, on the website or whatever, to confirm that the scientific organization or society is obviously having the conference. So at worst, you can show them that you are a person working in that field and that you are hoping to attend said conference. My sense would be that perhaps the society would at least be able to provide some type of communication to that individual, to that applicant, to sort of confirm that the conference is ongoing and that he or she may be attending. But the other situation is, going back to the 214B part, what are you going to do when you come home? So the invitation to come to the United States is but one part of it.
And we have one more question on the invitation letter, which I want to get to, and then we can sort of switch topics a little bit. But this is a good one. How should a society deal with requests for invitation letters in cases where the requester may not be a potential attendee? My particular society has had cases of bogus visa invitation requests, and we have declined to provide a letter until the individual has registered for the meeting. Are there any potential liabilities that the society would hold if they provide a letter to someone who turns out not to have the proper intentions?
That is a good question. And, do I have a great answer for that? I think that the society, my personal view would be that as long as the society did their own due diligence on this individual, and it seemed to be a bona fide and proper, I suppose, request for such a letter, I would not foresee any liability to the society, given that they would have been acting in good faith to provide the letter and would have done their own due diligence. If, for example, Dr. A, Mr. B, or Ms. C requested said letter, that their credentials checked out, and that it seemed that they were requesting the letter under a legitimate circumstance, then the society, I would feel, would be acting in good faith. What are the other options? I mean, that ultimately, I suppose, is up to the society or the organization itself. But, my sense is that if the society organization acts in good faith, the credentials check out, then I would not see that they would be seen to be liable. Now, I think perhaps taking that one step further is, however, if it was to happen, unfortunately, that there were a number of situations or occasions, or a society saw a trend of a number of people trying to utilize invitation letters from that society, then perhaps they would have to, strengthen their own review. But that's a difficult one to quantify. I would say that if you saw a trend in terms of multiple individuals trying to obtain a bogus invitation, for want of a better word, then you maybe need to up your own level of scrutiny as to who these applicants are.
Going back to just, after the application process, one of the pieces of advice that you gave was about keeping in touch with the local consulate while the decision is either delayed or under review. So, you have any advice on the best way to do this? Is a phone call the right way? An email? Should you request another interview? How do you continue to kind of keep up this relationship without becoming a pest?
Right. All of the above. Usually how I would tend to process this type of sort of level of communication with a consulate actually would be in that order. The first one would be a follow-up phone call. If you can, and again, I'm generalizing hugely here because some consulates have different manners and means of communication, But under normal circumstances, if you were able to make a phone call to the consulate and leave your information, then the hope would be that would be the little nudge that would allow the officer to finalize that particular case. If that didn't happen, then the next step would be email, because then you've got the record of it, and then you sort of raise it to potentially another in-person request. And again, this is going to go back to the start early, because obviously in the world we live in, everything has to be instantaneous. But if you are communicating or contacting a consulate, you also have to give them time on their end to actually process the request. So if it's a phone call and or an email, you're talking probably, up to 30 days to potentially get a response on that. So now you're getting into months. But yeah, phone call probably followed by an email or two, and then requesting another interview would be the way I would approach it.
You also talked a little bit about this issue of establishing home ties, and we just had a question that came in. If on the home tie sort of requirements and things like that, you noted that applicants should try and provide either a contract or letter of employment or something like that. What if a researcher doesn't have an employment contract, simply just as an appointment at a university abroad? What kind of documentation could they use to satisfy that requirement if they cannot prove that they actually have, some kind of a contract or something?
Mm-hmm. So yeah, I mean, in a lot of places there'll be a letter of appointment. I think what one could do is you could show your letter of appointment. You could show your most recent wages. If, for example, you had the equivalent of 2 years worth of W-2s or whatever the equivalent was in that country, that you had been there for an extended period of time. Some of this you're not even going to have the opportunity to provide to the officer, but let's say, for example, from a researcher standpoint, if you had been working on a grant that is a 5-year grant and you're 2 years in, the inference therefore is that you've got three more years of research funding to support you. So I think things like that could be beyond a contract per se. Ultimately, you need to be in a position to be able to convince an officer that you will return home, and that what is there to make you return home or get you to return home.
Another issue that you talked a little bit about was this issue of not engaging in unauthorized employment. One of our attendees wants to know, what activities are considered to be unauthorized employment? Are there certain triggers that would raise concerns?
This is a real gray area. What is unauthorized employment? How I tend to view it is that, are you engaging in an activity that would, even if you're not getting paid for it, I mean, if you're going to start getting paid to do things, then you're being employed, more or less. But let's leave the compensation out of it. If you are engaging in activity that, but for not being paid, would otherwise be employment, then you're at the very least skating on thin ice. And what do I mean by that? I suppose that in certain circumstances, certain organizations, in certain times, there are what I would call bona fide volunteer opportunities. And that's fine. But let's say, for example, you're in the United States on a visitor visa, and again, someone asks you to come and collaborate in the lab for a period of time. You're close to, if not engaging in unauthorized employment, because generally speaking, someone else would be paid for that activity. So it's a tough one. Again, how things are being viewed right now, I would tend to err on the side of caution, but that would be my normal sort of how to look at it. If the activity would normally be considered to be maybe paid activity and or activity that someone would consider to be employment as such, then it's probably unauthorized employment. You're probably pretty close to that, if not there.
This one is an interesting question. We were told that if members were having trouble getting visas to come to our meeting, that they should reach out to the State Department Bureau of Consular Affairs. Do you think that's the right step and approach, or is it better to work directly with the local consulate or have this person reach out to an attorney?
Oh, that depends. I think my answer to that question, which is not exactly, I'm looking at it right here, and it's not going to be exactly on point, is that I think it depends upon how the person approaches their own situation. Because as we sort of discussed a little before we went live, one of the issues, and possibly one of the biggest issues, is when somebody goes in not properly prepared. Because if you walk in unprepared and that application is denied, now you're, to use the old pool terminology, now you're behind the 8 ball. So I think any of these, how to approach it, is not necessarily one of those is better than the other. I think for the majority of people, probably working directly with the local consulate is fine. But again, as I sort of noted at the outset of this webinar, that there are a bunch of different consulates and different rules that are different. So yes, for some people it may be that reaching out to a separate portion of the State Department may be beneficial in this case to set their platform. Some people, depending upon their circumstances, it may be beneficial or appropriate to reach out to an attorney first. But I think whatever manner or whichever approach you take, to be well prepared and have all your material together and ready is the most important, because second chances might not come around. That's what I will say. So I think be prepared and being well prepared and organized is the best advice to give. And depending upon where you're applying, your personal situation, one of either of those may be appropriate. I don't want to sort of fudge it, but again, I think depending upon a person's personal situation and the location may drive the answer to that ultimately.
This next question is coming from someone who is interested in your thoughts on the social media issue. Do you recommend, or what's your advice on social media? Is it a good idea for a visa applicant to limit their use of social media while their application is under review, or does that actually raise more suspicion on the part of the consulate?
Yeah, that's a good question. And that's, again, it can be a hard one to answer, because the social media issue, this is something that is a little difficult to quantify as to how much this is happening. My view is that an individual or an applicant should not have to reduce or limit their own personal access or use of social media while an application is pending. I mean, the bottom line is social media is now part and parcel of our day-to-day world. So I don't think that it's necessary to say, well, I'm going for a visa appointment, so I'm going to limit myself on social media. And I'll choose my words carefully here. Whatever an individual's social media history is will potentially drive their own decision. But I don't think limiting a person's use of social media should be a driving factor. But I just think that people should be aware that it's now more in play than it used to be.
That's helpful to know, especially since we don't know what the State Department is going to do. They have this initiative underway. They've issued a notice of proposed rulemaking, so they're in the process of potentially forthcoming a regulation on this issue, but we don't know what things are going to happen with that. Don't know if you can answer this question or not, but one of our participants wanted to know, from your experience working with scientists who have applied for visas, is a visa applicant more likely to be approved if they have a specific speaking or organizing role associated with a scientific meeting and conference, versus just being someone who wants to attend for professional reasons?
Yeah, I mean, possibly. I think, again, a lot of this goes back to a particular consulate and dare I say it, a particular consulate officer on the day of the interview. We, unfortunately, for better or for worse, run into a lot of inconsistencies in terms of the consulate process. So, yeah, I mean, I think that it's fair to say that if you turn up and are in front of a consulate officer and the consulate officer is a sort of relatively pragmatic and decent human being, that to see that, okay, this person has been invited to speak, that gives another reason. But again, I think it's important to just keep in the back of our mind, with whatever the issue is coming to the United States, to always keep that 214B issue, home ties, in the back of our mind, because whether you're coming to attend, speak, or whatever, that's the consulate officer, him or herself, is going to be thinking about that on the back end. So I think, yes, it's possibly gives the consulate officer more of a reason, or an easier reason, if we want to say that, to issue the visa. But again, all of these other factors that we've talked about today are still in play.
Another person had wanted to get your thoughts a little bit more on the travel ban, particularly the restrictions on the affected countries like North Korea, Iran, Syria, etc. You noted that their waivers have been granted, but they are very aware. Are you aware of any waivers that have been granted for travel to scientific conferences and meetings, or if there's some kind of exception for that?
So, no, I'm not. I mean, at the outset, I am not aware of that per se. What I would say is that in the language contained, scientific conferences and things like that are noted and mentioned. And there's a lot of other stuff that's noted and mentioned in terms of national interest waivers and things like that. So the idea of travel for a scientific conference or meeting is noted there. The extent to which this has happened or can happen, I don't have specifics on that. There was a Reuters article in early March, which indicated that the issuance of said waivers are extremely rare. So we can probably go back and try and, dig out some specifics or details, but personally, I don't have any examples as, per se examples.
A question on tactics from one of our participants. If an applicant is denied a visa on the first try, should she or he consult an immigration attorney before applying again, or what's the best way to sort of respond?
Yeah, I mean, I think it depends firstly on what the denial was for, what transpired, and how in fact the individual or applicant presented themselves. So I think it can depend a lot on what transpired at the original application. So what I would probably suggest is that, yes, they should probably talk to someone, consult an attorney, to at least get a sense of, okay, what was done perhaps incorrectly the first time, because once you go back for a second application, generally speaking, that second application has to be at least fairly discernibly different. The presentation and the manner or the structure of the subsequent application, you have to bring something else to the table. So if you were to simply go and revisit it and refile it yourself, you may not be making much of a change, and the officer may just be like, well, hold on a second, what else are you bringing me here? So I think it would be, at the very least, good to get a second set of eyes on it.
We're coming to the end of our webinar now. We only have a few minutes left. We did get another question that actually might serve as a great summary in terms of all the wonderful advice you'd offered us here. But could you elaborate on the kinds of documents that would need to be presented for a visitor's visa to really ensure that you hit all the targets that you said about being prepared and presenting the best case?
So yeah, I mean, when you get into some of the documents, I mean, I think you look at it from a two-step point of view. You look at it that you are coming to the United States for a bona fide, legitimate opportunity to attend a scientific conference. So, for example, you have your letter of invitation. If your abstract has been presented, you will want to have confirmation of that, and your hotel reservations, and so on and so forth. So that really would show the officer quite quickly that you are coming to the United States for this legitimate, important event professionally. And then on the back end, you also have to, in this very small window, this very small time window, you have to also convince the officer that not only are you coming to the United States to do that, but you're going to return to your home country. So this will be the opportunity, and again, be organized, be prepared, but to have that letter of employment, to just go back over a little old ground that we mentioned a couple of minutes ago, perhaps that could be wages, perhaps that could be housing, leases, the equivalent of a mortgage, that if more likely than not, if you have a spouse and or children in school, be prepared to show that. Be prepared to quickly confirm and provide documentation that there are ties to your home country and that you will return there. And once you're able to do that, that should put you in a good position to make a solid application for the visa.
Well, I want to go ahead and thank Brendan for all of the help that you provided with us. Again, this webinar was not intended to answer every specific question or address individual circumstances. It was more to provide a general overview, as we know that this is an issue of concern broadly to the scientific community and also to FASEB member societies. So for the FASEB member society folks who are on the line, please know that the Office of Public Affairs is continuing to track this issue, and if you are having questions or issues or concerns with your meetings, please be in touch with us so that we can continue to work on our strategy for addressing this, particularly as some of these issues move through both the legislative and regulatory process. Also wanted to remind folks that, again, we've recorded this webinar and we'll provide access to this by end of next week on our website. We also have Mr. Delaney's contact information here. If you do have a specific question and want to reach out to him, we cannot guarantee that he can answer all of them, but we did want to provide that as a resource. So thanks everyone for joining us today, and enjoy the rest of your day.